Now I'd like to recognize Mr. Massey for 5 minutes.
Thank you, Madam Chairwoman, for having this important bipartisan committee hearing. Ms. Daria, you touched on speedy trials, and I'd like to relate a story from when I was county executive. Our biggest line item in the budget next to the roads was the jails. And I noticed a pattern over there. We had overcrowding, and they were always trying to get us to build more jails. And that wasn't the problem. The problem is we had too many people awaiting trial. But there was this perverse incentive for the judges at the state level to keep inmates in there because they would pull them out after 16 months and then encourage them to plead guilty for time served. Now, the interesting thing is the counties paid for the time served. It went to the county budget, and the state didn't have to pay for the incarceration. So in Kentucky, at least, we've got the state pushing the burden of incarceration, the fiscal burden, onto the counties. So they have this incentive to get the inmates to serve time in county jails before they come up. This wouldn't be a problem, and unreasonable bail wouldn't be a problem if we actually just followed the Sixth Amendment, I feel like. What is right now the accepted threshold for a speedy trial and has, in the Supreme Court or elsewhere?
Well, as you've described, even just in describing the county and state differential there, the rules differ by state. Our criminal justice system is a completely, piecemeal jigsaw puzzle of rules and statutes, and the approaches to them have been different everywhere, particularly in the pandemic, when a lot of jurisdictions attempted to address their speedy trial statutes and to expand the time that people could be held to try to manage the pandemic. DOJ did that for the federal government as well, where U.S. attorneys were seeking to enlarge the time that people could be held. So there's no clean answer to the question of how long people are traditionally held or generally held in different places. I do think that your question touches on a bunch of these different issues that people have been discussing today because they all relate to each other, right? The question of pretrial detention being part of how pleas are coerced, and the question of whether discovery is provided earlier in the process so that people can make decisions and move on. These are all interconnected, and they relate to the amount of time that people spend pretrial and to when and how they can make informed and voluntary decisions. So I think they're all interrelated.
Since you mentioned discovery, that's a good transition into my next question, which deals with facial recognition. And you sort of have the same problem, I think, when you use canines to establish probable cause. How do you cross-examine a canine? And I think you shouldn't be able to use a dog to establish probable cause, because really it's up to the handler to say that the dog saw something or smelled crack instead of a cheeseburger. And but now I'm worried that we're going to have the same problem with facial recognition. How do you cross-examine an algorithm? And will the Brady material be available? Did the algorithm identify 10 other suspects that aren't being prosecuted? And is that made available? So if any of the witnesses would like to speak to that, I'd like to open that up for a brief comment.
Yeah, I can address that. You're absolutely right in terms of facial recognitions, because there is no clear discovery of close matches. And the way it comes in courts right now is that it's viewed as a quote unquote investigative lead, right? So we don't even have to, it's an investigative method. So we don't even have to disclose it to you. And if I could go back just 1 minute, because Mr.
I'll give you 30 seconds.
Yeah, but you made a great point about pretrial detention and exactly the situation you described. And I don't want to leave without calling attention to holistic representation. There's this amazing study out of the Bronx where they compare holistic representation to traditional defense. And it found that over a 10-year study, that in terms of pretrial custodial sentences and custodial sentences overall, a 15% decrease of 1.1 million fewer days of custodial punishment. It was a huge savings. It's a much better way to do defense, and it really will promote safe communities.
Thank you. In my remaining 30 seconds, I want to point out that the racial and economic injustice extends beyond those who are incarcerated. Ms. Camara mentioned that African-American males are 6 times more likely to be incarcerated than Caucasian males. Well, when you go do an instant background check to purchase a firearm, it turns out that within races and ethnicities, a lot of people share the similar surnames. And I've been trying to get from the DOJ and the ATF, because they collect this data, the false positives that occur at a higher rate among minorities when they go to try and purchase a firearm. There were 112,000 denials in the last year we have data, and only 12 prosecutions. Most of the denials are false, and I am very concerned that a lot of those denials are racially biased because of the mass incarceration of African American males and the fact that a lot of Latinos share surnames among them. So maybe we could get that data from the DOJ at some point. Thank you.
Mr. Massie, your time has expired, and even though your particular example will be challenging to some of us who certainly want the legal purchase of gun, but we certainly don't want the illegal purchase, but you are
Right.
making a very good point. I hope that we'll have a bipartisan opportunity to work on some of the issues that you raised as
Thank
it relates to pretrial detention and pretrial procedures. Thank you so very much for your questioning.